morning, viewers. This is episode 6 of the Slarskey LLC video series on specialty finance and litigation funding. In this series, we explore hot topics in the legal funding market and related asset classes. Today's episode focuses on legal ethical issues within the funding market. I'm Evan Freed. I'm a partner at Slarskey LLC. We are a New York-based litigation boutique. Among other areas of litigation, we focus on litigation funding related disputes, including legal ethical disputes, fee disputes, disputes among funders, as well as malpractice actions. Today's episode focuses on legal ethical issues in litigation funding, and I'm pleased to be joined today with the man who literally wrote the book on legal ethics within litigation funding, Professor Tony Sebok. Tony, happy to have you here today. Do you mind giving the audience a little bit of a background on who you are and how you got into this litigation finance stuff?
Yes, absolutely. And thank you for inviting me to do this. So really briefly, I am a law professor interested in civil litigation. I've taught torts now for over 20 years. And sometime around 2004, 2003, I got interested in the question of why there wasn't literally venture capital in litigation. That was a topic I wrote about, and basically speculated that there should be more opportunities for third parties to invest in litigation the way third parties were investing in startups. I got contacted by a lawyer who was interested in creating a company that did just that. I advised that company. That was Juridica. I advised other entities that are interested in that, including Credit Suisse. And then eventually, because of my writing and advising in this area, I was approached by Burford Capital. And in 2010, I began exclusively consulting for Burford Capital. I've also, with Burford's permission, been able to consult with other entities, including a nonprofit called Justice Catalyst. Justice Catalyst does litigation finance for nonprofit purposes, helping social justice litigation issues. I am Burford's ethics consultant. I also advise law firms sometimes, and I have served on numerous governmental and international committees to sort of recommend reforms in law, recommending changes in regulation. And it's basically consumed my life as an academic, and I've written lots of articles about this. Nothing I say today, by the way, reflects the views of Burford or any other entity for whom I provide consulting services.
Oh, that's great. Well, I was not kidding when I said that you literally wrote the book on legal ethics within litigation finance. Why don't you tell the audience a little bit what you've been working on recently?
Well, so I hope this comes up. Yeah, so that's a view of my new case book. It is the first case book published by Aspen, which law students and lawyers recognize as one of the major publishers, the Red Books. It's for a course in litigation finance. I've been teaching that class now at NYU, and I've been teaching it for a few years now. My materials eventually grew into a book. Aspen decided to publish it, and I hope, and I know other people are adopting it this coming semester in different schools around the country. So that's one of the sort of scholarly things I've done. I've also written articles.
Well, I don't mean to outdo you here, Professor Sebok, but I too have a textbook here, The Law and Business of Litigation Finance, which you've contributed to as well. The most recent edition, which launched this summer. Chapter 3 on regulation within litigation finance, our firm contributed to as it pertains to propose an actual legislation on the state and federal level here in the United States.
Yeah, and in fact, for the audience out there, this I think is both self-interested and also public interest. There should be more being done at the law schools about this. So everyone out there listening to this podcast should think about their own law school where they went to and go back and say, why aren't you offering a seminar? Why aren't you offering even a mini course in this? I once taught a mini course at Vanderbilt on this topic. Vanderbilt has offered that mini course taught by a number of different leaders in the field. Other schools could handle this in a 2-week mini course during intersession. It could be a seminar. Obviously, it's not going to be a big lecture course, but so what? I mean, but I think that law students and practicing lawyers need more education about this topic.
Yeah, for sure. I want to, in talking about legal ethics today within litigation finance, look, much has been said. People have written about, champerty and all types of doctrines till they're blue in the face. But I want to focus specifically on an article that you recently wrote for the Wake Forest Law Review called "The Rules of Professional Responsibility of Legal Finance: A Status Update." As it pertains to this article, what compelled you to write the article, and why? If at all, did you feel that some of the historic commentary on litigation finance kind of, sidestepped or ignored certain other issues?
Yeah, so actually, the article came out of a project I did for the plaintiffs-oriented group, the AAJ.
Okay.
They asked me, they said their members have been approached by clients to do to assist in the clients securing litigation finance, and there's a lot of questions out there. Solo practitioners, small plaintiffs firms wondering, well, what are the ethical pitfalls, if any, that I need to worry about? So I wrote a report for them with Brad Wendell of Cornell, and then that report morphed into this larger law review article, which is essentially pretty straightforward. It's not, what I consider to be an ambitious academic or sophisticated thing. It's really a survey. It's a service project on my part, a survey going through the model rules, which I teach PR, going through the model rules and seeing which ones are relevant to a transaction that a client does that brings the lawyer in. And in that sense, it's really a mirror image of similar articles that people have written and treatises people have written for lawyers whose clients have liability insurance.
For sure. Yeah, the article talks about an attorney's duties, in so-called plaintiff-directed funding, right? Where the
Right.
plaintiff signs a contract directly with the funder. But that's not to say that the lawyer's not involved. In
Of
fact, in
course.
many ways, the lawyer is the jockey. What are some of, and it's a practical approach, right? It says these are the duties that, if you're a lawyer,
Yeah.
implicated by
Well,
plaintiff-directing
so
funding,
I'm
what
not,
are some of the
so
duties?
you have to help me out here, because obviously we could just go through the article, but anyone could just like eyeball the article and see the section headings. Like, the most obvious low-hanging fruit is communication, rule 1.4, but I don't have to tell you that. Every lawyer knows that whatever the matter is, the lawyer has a duty under rule 1.4. What's the limits of that duty? How will a lawyer know in advance whether or not a client won't, hypothetically speaking, file a bar complaint under rule 1.4? I think this is actually not a trivial point. When you look at the statistics, violations of rule 1.4 are often the most alleged violation. They get thrown in often by angry clients who just don't like what happened to their matter, rather than any substantive complaint. But it's easy to write it down and send it to the bar association, say there's a violation here of the duty of communication. Having said that, it doesn't mean that there isn't a duty. It's just pretty easy hurdle to clear. There are other duties that are a little bit more complicated, that are harder to clear. Confidentiality, 1.6. Again, no lawyer is going to be surprised, if they thought about it for a moment, to realize that if your client comes to you and says, I have a stranger, there's no common interest here, who wants to look at materials that have been prepared for this matter, confidential materials that the lawyer otherwise could not disclose to anyone without the client's consent. And then the client says they want it. Well, the lawyer's response is going to be, it's your call. But again, the lawyer knows so much more than the client does. The lawyer has a duty under a variety of rules, including competency and communication, to inform them about how to operationalize the 1.6 duty. So 1.6 is actually introduces a whole new group of duties. And we could go on. We could talk about personal interest conflicts of the lawyer. We could go on and talk about duties having to do with private side deals between the lawyer and the funder. I don't know how much detail you want me to give you about these different duties, 1.8, 1.7. You could just walk right through the rules.
Sure. I mean, that what I found interesting about the article is you talk not just about the professional conduct rules, but also, common law duties that a lawyer might or might not have in these types of situation. And what I found particularly interesting is this question about fiduciary duties, as well as what I think you call the contractual fiduciary duty as well. Why don't you walk the viewers through, where you believe that sort of shakes out?
Right. So there has been, this was really, this is where I think I add a little bit of value to the conversation. I've been contacted by journalists, primarily journalists, legal journalists, who said to me, it's interesting. There are these lawsuits being filed around the country by funders against lawyers. Could you
Hmm.
explain to me why funders are suing lawyers? And the answer is, and it's really sad and ugly little sort of stories here where, in particular, some funders more than others, and I don't want to name names, but there are some funders out there who I think are not helping matters by aggressively suing lawyers after the inevitable, out of every whatever 100, 1,000 typically consumer, but not exclusively consumer litigation finance contracts, some of them are going to go south
Hmm.
for whatever reason. Um, and a lot of things happen when they go south. One of the things that happens when they go south is sometimes the funder, after they exhaust all the opportunity to recover any money from the client, goes after the lawyer, right? And then there's a variety of legal theories that clever or not so clever lawyers can come up with. One of them is arguing that the lawyer owed a fiduciary duty to the funder in some way
Hmm.
because they may have actually made obligations or promises in communications with the funder when the client was trying to obtain the funding. That I think actually is mostly just smoke and mirrors. There may be fiduciary duties between the lawyer and the client. In fact, by definition, almost every uh, duty in the rules of professional responsibility will then track a fiduciary duty under state law, but that doesn't really add much extra obligation. It's really when there's a new obligation the lawyer never conceived of having before to the funder that the lawyer has to be concerned. And there, my purpose was to suggest that if you get an angry letter from a funder saying you breached a fiduciary duty, most of the time you can basically say, no, I don't think so. Where things get even trickier, though, is where the lawyer has actually signed a side agreement with the
Sure.
funder. And some of your audience may be familiar in the PI space with letters of protection. Letters of protection are truly a subtle and complicated thing. I don't want to say that they shouldn't exist. I will say that not every jurisdiction treats a letter of protection as a thing. Letter of protection sometimes are just a kind of shorthand for an obligation that existed anyway under the rules of professional responsibility to protect the property of a third party. But there are some jurisdictions that actually give a little backbone or some spine to the separate actual counterparty relationship between a lawyer and a third party lien holder, such as a medical provider. Funders have tried to leverage that. They've tried to get lawyers to say, hey, if you're signing letters of protection to the hospital treating your patient, you should sign a letter of protection to us too, because we're giving your patient, giving your client something of value. Again, my answer to that is I don't think so. And to the extent that state law in a jurisdiction does provide a new and extra obligation on the lawyer's part, I think lawyers should be very, very careful before they sign those letters. They don't have to sign them. Remember, a lawyer providing advice to a client who seeks funding is giving the client an extra service that the lawyer otherwise would not be obliged to give. This is a business transaction between the client and a third party. The lawyer is being hired to provide legal advice, not to provide business advice, and certainly not to assume a new obligation to help the client secure a financial advantage that they may want. The lawyer can do that. Client service is our watchword. Of course, especially solo practitioners and small firms want to provide client service, but a lawyer should not make the mistake of confusing client service with doing anything that could create an obligation they can't handle, and most importantly, putting anything down on paper that obliges them to then violate an existing duty they have to the client. And this all comes from insurance law. I mean, we've seen this before. We've seen this movie before. This happened in the 70s and 80s. Lawyers were confused when liability insurers began to demand certain kind of promises from defense lawyers that the ethics committees began to say, hey, you can't actually do that.
For sure. Well, look, up till now, we've talked predominantly about plaintiff directing funding, and you've gone into some
Client directed funding.
Concepts concerning, plaintiff advances and whatnot. Let's talk a little bit about your article and as it pertains to attorney directed funding, whether that be a loan to a law firm or, what the industry is calling portfolio financing right now. And, we all lived through it over the past, 5 or so years. I mean, there was some confusion here in New York based on the New York City Bar Association opinion that came out several years ago, which sort of muddied the waters on this front. Why don't you walk us through, the competing decisions or the competing opinions of here within New York and as they pertain to attorney-directed portfolio funding?
Yeah, so I want to be very careful here about what I say because I don't want to mislead anyone. The most important thing that I think I would say on this topic is that it is still unsettled what actually is the status of lawyer-directed funding in New York State. And what it is the status of lawyer-directed funding in all jurisdictions. Now, to be clear, here we're talking about two very different constraints on an attorney. As a matter of state common law or state legislation, but it's almost all common law, every court decision that has ever examined a contract between a lawyer and a litigation financier, what we might call lawyer-directed funding, a non-recourse advance, whether it be called a forgivable loan or a non-recourse advance with a premium upon the happening of some contingent event. Every court in the United States that has ever reviewed these contracts have viewed them as enforceable, have not declared them as unenforceable because of public policy. There's this famous Delaware decision that talks about how lawyers can't hide behind legal ethics to avoid what obligations that any other private party would have to perform. So then the question is, well, if it's as a matter of private law enforceable, is it permissible as a matter of legal ethics? And there, I think the question is, well, just legal ethics has to catch up to the real world. I mean, the real world is that contract law says that this is okay. Policy suggests it's okay because, as far as we know, there have been almost no, with the possible exception of one very famous story, which we can talk about later in the commercial context, there's almost been no established risk to clients of lawyer-directed funding. Full stop. Clients don't mind it, funders want it, and lawyers can sometimes benefit from it. So then the question is, well, what does 5.4 say about it? And what 5.4 says is you can't share fees with a non-lawyer. And my view has always been is that these are not fee-sharing agreements. A fee-sharing agreement where historically they've been involving professionals who assist lawyers, like private investigators, et cetera. That's not what's happening here. No one's providing a professional service on behalf of a client with a lawyer. All that's happening here is the lawyer is securing capital. They're securing money for the practice of law, much like a loan. The risks to the client of a lawyer securing capital from a non-recourse funder, as opposed to securing capital from a recourse provider of capital, such as a bank, are on a spectrum almost identical. In fact, one sees covenants in recourse loan arrangements between banks and large firms in the financial crisis of 2008 that gave those banks a great deal of say about how those firms operated. They required those firms to get rid of personnel. I mean, that's going to affect the client's service as well. In any event, these are the facts on the ground. As a result, I would say that there has been no clear answer about what 5.4 prohibits and permits with regard to non-recourse funding. There was, I think, a poorly reasoned opinion in 2018 from the New York City Legal Ethics Committee, which I'm now, until the end of this summer, a member of. I wasn't then a member of it. We issued an opinion this year, which talks mostly about client-directed funding, but sort of does point out that there is an open question on lawyer-directed funding. And then the New York City Professional Responsibility Committee, which is a different committee, published a report, not an opinion, a report suggesting that for the sake of clarity, Rule 5.4 in New York should be changed to permit lawyer-directed funding as long as there is advance notice to the client that it is a possibility, so that clients can choose to limit and restrict the scope of representation, including the lawyer's decision about how to personally finance their own internal practice, which a client can ask to do, because obviously there's going to be some potential impact if a lawyer chooses to finance their work for a client in a certain way.
So far, we've talked about Model Rule 5.4 or New York Rule of Professional Conduct 5.4 through the lens of fee splitting, but actually, those rules are broader than just fee splitting, which brings us to our next topic, which is, pretty popular topic of discussion in the litigation finance and legal ethics world, which is alternative business structure, or ABSs. What's an ABS, and why do we care about this in the context of this discussion?
Right. So it's a very important and critical distinction to understand that the policy behind Rule 5.4 always was about a policy concern that has nothing to do with the advancing of capital to be passively invested into the operation of a law firm. Because with passive investment, just like with a loan, the risks are pretty minimal, and they're very, very, I think, easy to constrain with the existing rules of professional responsibility to prevent the influence or interference of the lawyer's conduct by a non-lawyer. I mean, there's always a residual risk that a lawyer is going to be influenced to do unethical things, but the rules are there to stop that, and they do stop that. On the other hand, there's no doubt about it that if a lawyer chooses to start engaging in a professional association with a non-lawyer as a partner or as a key employee, the non-lawyer is going to have some effect, potentially some effect, on the output that is provided to the client. The client's experience, the client's provision of services will be affected by that non-lawyer. That's openly admitted. That's the point. Lawyer-directed funding has nothing to do with that. There are other parts of Rule 5.4 that do prohibit explicitly partnerships between lawyers and non-lawyers, or explicitly prohibit the employment of a lawyer by a corporation, or explicitly prohibit the ownership of a entity that provides legal services by shareholders who are non-lawyers. Now, around the world, this is permitted. In England, this is permitted. In Europe, somewhat it's permitted. Under other parts of 5.4, not connected at all to the lawyer-directed funding issue, it's prohibited. Arizona has gotten rid of all that. So Arizona basically says that all of 5.4 is struck. And in its place, Arizona has established something called an alternative business structure, which does have regulation, does have oversight by the Arizona Supreme Court. And essentially the argument being that, and this is something which is a variation of what we have in Washington, D.C., where a limited non-lawyer partnership structure is permitted, that the same rules of professional responsibility which protect the public, that oblige only people who are members of the bar to provide legal services to persons in a jurisdiction, those rules can also be applied against entities that provide legal services if non-lawyers are part of those entities. And that's what an ABS is. And that's how the ABS is structured as a way to protect the public from bad consequences coming from non-lawyers who are working with lawyers in the provision of legal services. The idea being that those rules that are constraining the lawyers are going to be extended over the non-lawyers, and lawyers have to be involved in the management of the ABS to make sure those non-lawyers understand what those rules require.
Right. And, this can create, a bunch of gray area, or at least questions as to what a New York lawyer can do vis-a-vis an Arizona ABS or a different ABS. And this was recently tackled in a New York City Bar Association opinion as well. What I'm talking about there is the Committee of Professional Ethics Formal Opinion 2024, lawyers associating with alternative legal business entities. And why don't we just go check off the boxes on this one? The article raises a series of questions or series of permutations as to how this can implicate legal ethical duties. And one is, can a lawyer, a New York barred lawyer, practice within an ABS?
Yeah. So I think the answers are complex, but they are also reasonably consistent with prior analysis.
Sure.
This is not a new question in the sense that as long as outside the United States, non-lawyers could be owners of legal offices, law offices, however you want it to, whatever term. In Italian, you have legale studio, right? In Italy, it would be a chambers, right? To the extent that we can identify a law office as a functional equivalent of a lawyer barred in a jurisdiction in the United States, which is essentially what you have to do. It's an initial question. I mean, someone comes from overseas and says, I want to appear before a tribunal. You want to know, are they a lawyer? What does that mean? They don't have the same university system. They don't have the same licensing system, but they do have things that are analogous, and we know how to do that. So to the extent that you have entities that are law offices outside the United States that practice law with American law firms, this question comes up, and this question's been answered. So could an American lawyer, or could a lawyer in New York or a lawyer in DC share fees with a British law office, with an Italian law office? The answer is yes, they can. Can they become a partner in a law office overseas, owned by a office overseas practicing law in New York? No, they cannot. I mean, you cannot get around through the back door, so to speak, limitations on American legal ethics rules by simply saying, well, I'm actually a member of a foreign law office. If you're predominantly practicing in a model rules jurisdiction, you have to follow the model rules in your jurisdiction. But that doesn't mean that you cannot share fees with a foreign lawyer. You can share fees with a foreign lawyer because the foreign lawyer is governed by their rules. You're allowed to send part of your fee over to them, and they can share it with non-lawyers where they are. Okay, so those rules have all been examined over the last 20, 25 years. All you do now, and all New York has done in this opinion you're talking about, is take that logic and apply it to Arizona. Treat Arizona the way we treat London. Treat Arizona the way we treat Rome. Full stop.
Sure. And it seemed fairly obvious to me, but the punchline of the article was, can a New York lawyer invest in an Arizona-based ABS? And the answer to that is, yeah, provided it is that lawyer is a passive investor. And the logic is even incredibly simple. This is not the practice of law. This does not involve, legal ethics. This is a question of what people can invest in or not.
I mean, you can buy shares in an Australian law firm as a lawyer in New York. Okay,
sure.
Bet it. That doesn't mean that you're violating the rules of professional responsibility in New York.
Yeah. That's not to say that Arizona is, this issue of Arizona is not groundbreaking. For sure, look, it has existed in Washington, D.C. for lobbying purposes predominantly. But what's going on in Arizona and Utah to an extent is certainly groundbreaking. And I think you hit the nail on the head earlier, which is, this isn't the Wild West. This is a regulated thing that's going on, and it's regulated on several fronts. And I think you alluded to earlier, that the courts can step in these situations. Why don't you talk to the viewers a little bit about the one issue, the one case that has sort of come out on this front?
Yeah, and so the decision which you're referring to is, I'm just reading from the caption here, in the matter of a licensed ABS
Right.
legal help partners, came out this year. And I think what makes it interesting is less the substantive issues at stake and more just the fact that it happened at all, right? And in fact, the sanction was relatively modest.
Mhm.
I think this was really an opportunity for Arizona's leaders, the leaders in its bar and the leaders in the bar, in the Supreme Court, to make it clear that they were watching, that they were taking seriously any complaint about any violation of applicable rules. This ABS admitted, so I don't know what the facts were, but they admitted to violating some of the rules that would constrain any lawyer. I mean, basically, these were not rules that were unique to non-lawyer participants in an entity under an ABS. These are rules that if they had done them as lawyers themselves, not just in Arizona, but in any model rules jurisdiction, they could have been hit with a violation. Now, the truth is that there's some prosecutorial discretion here. The kind of violations they committed were not the kind that you often see being the subject of a major disciplinary ruling. So I think what happened here was that and again, this is not about suggesting that there was any impermissible or any sort of invalid conclusions here. These were all technically valid conclusions of the violations of the rules. But I do think it's important to say that this ABS got identified because someone complained. It had to do with not disclosing co-counsel relationships outside of Arizona, which is a sensitive issue because obviously when you have co-counsel relations and fee-sharing arrangements with other law firms in other jurisdictions, there's always a bit of concern that the client is not in full understanding of who their lawyer is. And I believe there was also, and this is interesting, a admitted allegation of a failure to use the trade name properly. And again, there has always been a bit of concern among the bar that the liberalization of advertising rules, the liberalization of marketing rules could erode the trust the public has in lawyers. And we don't, I think, want that problem to be imported into the ABS issue because it's a separate issue. And ABSs, raise their own set of unique problems, but they're not, I hope, going to become playgrounds for sort of sloppy and careless marketing techniques because we don't need that.
Definitely. Look, we've covered a lot of ground today. We've talked about plaintiff-directed funding, attorney-directed funding, as well as the new issue of ABSs in Arizona and elsewhere. I do want to thank you for joining us today, Professor Sebok. I guess on one final note, what are your predictions for ethics and litigation finance? What has not been covered, or what do you reasonably predict might be a new area that the courts or the professional conduct committees, will be venturing into soon?
Well, I do think that consumer protection will always be an issue. I think that both in model rules jurisdictions where there is client-directed funding like New York and jurisdictions like Arizona that have rejected Rule 5.4, I think appropriately so, and other jurisdictions may follow suit. The real world concern is not so much the commercial entities that work with funders, although that's where the vast amount of money lay, but they have their own, the counterparties have lawyers and they can probably protect themselves. and there may be some subtle and interesting legal issues that come up, but they're not going to be issues in which I think you need to protect the counterparties. The problem is the counterparties in consumer litigation finance. One of them is a finance company, may or may not be particularly sophisticated. The other one is an average person, a worker, a motorist. They're totally unsophisticated. They have their own lawyer, but their lawyer, as I mentioned earlier, didn't sign on to be an advisor about the litigation finance agreement. They signed on to help them with their personal injury claim. And they may not want to, or they may not be equipped to help them deal with the finance company. There is a risk there that bad actors are going to take advantage of consumers. And I do think that while lawyers are not directly involved in that, they're going to have to assist policymakers, and inevitably they're going to have to realize that they're going to be the target of a lot of anger. Clients are going to get angry with their lawyers when they don't like what happened, when they find out that the settlement they agreed to, a very large part of it is going to be taken up by legal fees, liens that have been placed on it by healthcare providers and the litigation finance company. And then who are they going to blame when they aren't happy with the outcome? They're going to blame their lawyer. And I think lawyers have got to be prepared for that. And they have to look around corners and they have to ask, how can we stop this from happening before it happens? How can we help clients understand what it is that they are giving up and what it is that they're getting when they make these agreements?
Well, Professor Sebok, thanks again for joining. Viewers, thank you for tuning in today. Again, this was the Slarskey LLC video series and podcast on litigation finance, and we will certainly see you in our future episodes. Thanks again.
Thank you.